Welcome back, everybody. I'm excited to be with you again for part 2 of our Parent Involvement and Empowerment in Special Education series. My name is Lindsay Pell. I'm a special education attorney with Disability Rights California. This presentation is designed to give you an introductory overview of the special education laws and procedures, as well as the IEP process. This one, we're going to go more in depth on the stuff that we learned in part 1, and then specifically focus on the laws that have created the special education system. So the key areas that we're going to review are what are the laws that require and define the IEP and the process for the IEP. So we're going to talk about laws that are both at the federal level and at the state law level. So the federal level, that law is called the Individuals with Disabilities Education Act, or IDEA is the acronym. It was reauthorized in 2004 and became effective in 2005. This laws basically sets the minimum floor for the whole country that everyone is supposed to follow for rights for students with disabilities. And then you'll see that in some situations, the state law builds on it. It gives a little bit more extra protection than the federal law. That state law is called the California Education Code. And so what you'll see as we talk through the process today is that every single right that you have in the IEP process and that your child has in the IEP process is coming from some law, either at the federal level or the state level. So major topics that we're going to cover are what is the process created by law for the IEPs and what does that look like for your child? What is that common term you probably heard in the IEP process, free appropriate public education, or FAPE? And then our other common term, least restrictive environment, or LRE. So we're going to start with FAPE. This is by far probably the most common term you'll hear throughout the IEP process, and it's a powerful tool for you to advocate for your child. It stands for free appropriate public education. So we'll go through each of those one by one. So free means, of course, everything your child gets in their IEP needs to be free of charge to you. So of course that means the school can't say, we're going to charge you for speech services. But it goes a little bit deeper than that. There's some things that are kind of something you would less commonly think of that implicates this right to services being free. So as an example, we've heard of situations where a school district will tell a parent that they need to come into the school and be an aide for their child. So while you're not being charged directly, of course, that's not free to you, right? Because you are missing out on work time or you're not being compensated for what you're being providing to your child. So that would not satisfy free. The district needs to provide any services to your child free of charge and also with district staff or staff from a private agency. The next is appropriate. So what that means is that the services and everything in the IEP needs to be targeted towards what is appropriate to your child. It means it's going to be meaningful to their needs and help them to make progress from grade to grade. So if your child has serious needs in the area of mental health, an IEP that doesn't have mental health services in it isn't going to be appropriate for your child because it's not going to allow them to progress. Public means that it's being provided by your public school district or by an agency that they're contracting with. And then education. Of course, all of this is about your child's education, which is their academic needs, their social needs, everything to help make them successful as an adult. LRE, or least restrictive environment, is the next requirement that's critical that every IEP has to meet. So what it means is that it's one thing for your child to receive their FAPE, but the next requirement is that that FAPE has to be provided as much as possible with non-disabled peers. So what that means is it's basically supposed to be a last resort to take your child out of general education and put them into a special education class or even a special education school. It's a last resort. As much as possible, the school needs to serve the child in general education. And the reason for that is that there's years of research that shows that in general, students are much more successful if they're educated as much as possible with non-disabled peers because they have the opportunity to be exposed to challenging curriculum and to form community with everyone in their school instead of being separated out, and to learn from behaviors that their peers might be modeling from them. It's also been shown to be a huge benefit for non-disabled peers as well to learn alongside students with disabilities. They learn that disability is not something that's negative or should be a stigma, that It's just a natural part of the human experience that people learn differently and interact differently. And it also means that it's more likely that the classroom setting will be targeted towards students with different learning styles. And that's a benefit not just for students with disabilities, but also for students without disabilities as well. And so least restrictive environment or inclusion is a huge thing to make sure that your district is satisfying for your child, that they need to make sure that they've tried everything to keep your child in general education before removing them to special education. So as an example, we often see that students who have behavioral challenges in the school setting, the district often proposes putting them in a separate classroom or even a separate school. And a lot of times they do that without first trying supports that could help them in general education to succeed. So as an example, many times we'll see that districts will put a student in a special education class before they've tried a behavioral intervention plan or before they've tried counseling services. And that's not actually in line with the least restrictive environment requirement. What that requirement is saying is that you want to first try and see if a student can succeed in general education, if they have all the services and supports that they need to meet their needs. And then, only then, if they can't succeed with those supports, then take them out and put them in a more restrictive setting. But you have to try those more supportive services first. So up next, we're talking about the 3 R's for parents: rights, roles, and responsibilities. They're interconnected throughout the process. Like we discussed in our part 1, parents are a huge part of the IEP process. They have rights to be involved at every point, and your input will make your child's IEP much stronger. And you'll see as well that the parental right to be involved in the IEP process is actually something that's guaranteed through the federal laws. So central parts of IDEA are specific requirements in the law for how the parent is going to be involved in the child's education. So one way that parents are involved throughout the process, we touched on this a bit in our last presentation, is consent. The parent has a right before an assessment is done to provide their consent to the assessment to give the district permission to assess. They have a right to have a copy of reports that are provided to the team. So any assessment reports, you have a right to get a copy of that with a written request. And without that consent by the parent, no assessments can be done. Timelines are another important right that's guaranteed in the federal laws and in the state laws as well. So one example of those timelines are with assessments. The assessments have to be reviewed at a meeting within 60 days of the date that you consent to the school district assessing your child. If there is a school break for more than 5 days in the calendar, then that 60 days is going to be paused to adjust for that. So as an example, the 60-day timeline is paused over the summer when schools are on summer break, or even during winter break if that's longer than 5 days. Eligibility is also something that's created under our federal laws. So last time we talked about how eligibility is based on the student meeting criteria to be identified in one of 13 disability categories, and that because of that disability, they need special education and related services to be successful in school. That is something that's created under those state and federal laws. Next up, part of the requirements of the IEP is the services that the IEP is going to provide. So every IEP, as we discussed last time, should include a statement of the special education and related services that are going to be provided to the child. It also should have a description of any program modifications or supports. And the goal of these services is to make sure that it's part of providing FAPE, right? So it should allow the child to advance appropriately towards attaining their annual goals, to be involved and make progress in the general education curriculum. And then also something that's overlooked sometimes is making sure that they can participate in extracurricular and other non-academic activities as well. These can be great sites where they can form connections with peers as well. And then remember, the least restrictive environment requirement applies to our services as well. So when we're thinking about our services, we want to make sure that it's promoting that opportunity for kids to be educated and participate with children without disabilities as much as possible. Remember, when your services are included in the IEP, they need to specify the location and the frequency of services in writing within the IEP. So as an example, it might specify resource specialist program for 20-minute sessions per week that are happening in the general education classroom, or a special day class for 5 300-minute sessions per week in the special day class, or speech for one 20-minute session per week in the speech room. Either way, it needs to be specific enough that you know exactly what to expect in terms of your child's services. So with the initiation of services, once those are offered, the team needs to identify when the services will be initiated, and that must happen within a reasonable time of the IEP concluding and you providing your consent to the IEP. The dates for the services to begin might be different though throughout the student's IEP. So as an example, if your child is receiving services in the extended school year or the summer, the start date will be a little bit different than their regular school year services. And the duration of the services is typically for 1 year, but in special circumstances, it might be less. The services must be reviewed at least annually, and then the student will be comprehensively reassessed every 3 years to look at their progress in all areas and redesign the IEP as necessary. So with the IEP, just like with the assessment part of the process, consent from the parent is key. So parental written consent is required for the initial placement and provision of special education services, and then also for every IEP after that. And refer back to our first training where we talk a little bit more in depth about how parents can provide their signature if they don't agree with all parts of the IEP. Something that happens sometimes as part of the IEP process is that a student is what's called exited from the IEP, which means that they qualified at one point but no longer qualify. And the reason for that is not that they no longer have a disability, but maybe that their disability isn't impacting their education in the same way that it once was. So we see this often with children that are really young and may have developmental delays than when they're younger, but then by the time that they hit kindergarten or first grade, they've closed that gap. Or maybe students that have just trouble with articulating particular letters and they receive speech services and they're able to gain that skill. However, before a district exits a child from special education, they have to reassess the student and determine that the student no longer has a qualifying disability that makes them eligible for special education services. But a district does not have to reassess a student if they would lose their special education eligibility because they're graduating from high school or because they're earning their certificate of completion. As soon as they have that certificate or have that diploma, then that means that they're no longer eligible for special education. But if they are going to try and make them ineligible before their education has ended, then it's critical that that is based on actual assessment results that prove that they no longer need that support. So in part one of our presentation, we talked through some other things that you might want to consider in your child's IEP process. And now we're going to get more into depth for those different topics. So we're going to start with assistive technology. Assistive technology is any type of technological support in the classroom that can help your child with their education. If you think that your child might need this type of support, then you need to request that the IEP team refer your child for an evaluation by an assistive technology specialist. So just like with any type of service, assistive technology is first established through an assessment to identify that there's a need and identify that there's a way to support your student. Like with all assessments, the AT assessment should be free and it should actually work in testing out different technologies with your child to see what they're responsive to. So make sure that that assessment report is actually reviewed together in an IEP. And then based on the results of that report, that any needed services are added to the IEP. So like with most other things that we've been discussing in this presentation, it's important to know that the right to assistive technology stems from the federal laws. So the IDEA actually requires IEP teams to consider assistive technology and whether that would be something that would benefit a child. And I think what we've seen kind of in our casework is that often this is an area that's underutilized. I think assistive technology can be really transformative for a lot of students, but it's not often something that's incorporated in their IEP, especially at younger ages. And so as a parent, if you feel like this might be something helpful for your child, it's important to request that assessment to see how it might support them. So next factor to consider is an independent educational evaluation. And we're going to talk through what the purpose of those are, what part of the assessment you might want more information on from the IE, Was the assessor qualified? When do you make a request for an IE? And is there anyone else who could do an assessment and get more valid results? So first off, what is an IEE? An IEE is basically an assessment of your child that instead of being done by the district, is done by an outside assessor and paid for by the district. So the purpose of it is if you feel that the district assessment might not have identified all of your child's needs properly, you may need a new assessment that might get a little bit better picture of your child and their needs. So you might do this for just a specific part of the assessment, like maybe you want more information about their needs in speech, but you feel okay about the rest of the assessment. You might do this because maybe the assessor who did the district assessment wasn't the proper person to conduct it. So maybe they had a school psychologist who did the speech assessment, and you want to get another look at it with someone who's qualified. So basically, to sum it up, you request an IE anytime you feel like the district's assessment didn't meet the standards of the information that you're looking for to guide the IEP for your child. From a legal perspective, you can request an IE anytime that the district's assessment doesn't meet legal standards. So examples are, like we discussed, that the assessor isn't qualified to conduct the assessment that they did, if the assessment didn't assess your child in all suspected areas of disability. In that case, you have the right to make a written request for an IE. Remember, everything as much as possible, always in writing. And when you do, the district must either agree to pay for the IE or they need to file a case to prove that their assessment was adequate. They are not allowed to simply say no to your request. IEs can be a really powerful tool to make sure that your child is really being assessed in a thorough way and that everything that could possibly support them is being identified. Behavior plans are another factor to consider for IEPs as well. These are a special added on feature to an IEP for students that have behavioral challenges that are impeding their academics. And the focus of the behavior intervention plan is to approach behavior in a positive way. So we're looking at the behaviors the child has, what behaviors we want to teach them as an alternative, and then what supports they're going to need to get there, to make that progress. The purpose is that these are not punitive. It's not about punishing the child for the behaviors, but about supporting them in a positive way and giving them positive recognition for the behaviors that are going to be more functional in a school setting. When your child does have a behavior intervention plan, it's really helpful if that is based on a functional behavior assessment. This is an assessment that's specifically focused on identifying what the child's behaviors are, what in the environment is actually reinforcing those behaviors right now, and what might be motivating to the child to start developing those positive behaviors. The benefit of it is that it's a structured data gathering process. So what that means is that it's actually going in and observing your child in the classroom, gathering data around those behaviors so that we're really identifying what the root causes are. And so strategies to address those behaviors are then not just based on guesswork, but they're really based on identifying the root causes of behavior and trying to have positive supports to guide the child. Another thing to consider in the IEP process is transition to adulthood, because everything we're trying to do through this IEP process is making sure that the child is going to be able to reach the goals that they've set for themselves as an adult. And transition planning usually starts no later than the IEP right before the student's 16th birthday, although it can be initiated earlier as appropriate. So if you have a student that's 14, 15 years old and already kind of trying to focus on what's coming next after high school, you can make the request to the IEP team that planning happens sooner. Because oftentimes 16 years old, the child is already getting relatively close to their graduation, and that may not leave enough time to plan effectively for the future. The transition plan must include the student's desires for their future. So it shouldn't just be the school identifying what a goal will be for them. They need to be involved in the process and identifying what they want to do after high school and what support they need to get there. Then one last requirement as far as transition is that at least a year before the student's 18th birthday, the district has to inform the student and the parent that the educational rights for the student will transfer from the parent to the student at age 18. So that means that the student becomes the person who's signing the assessment plans, who's signing the IEP, who is making decisions about their education. So now we want to talk next about what are the options available to you if there's disagreements with the school district. And I want to emphasize that it's always best to try to resolve those disagreements at the IEP level if possible, because anytime you can get agreement with the team, you can get buy-in with the staff who are actually day-to-day implementing your IEP, it's always going to be a more effective outcome for your child. But there are options if you can't reach that agreement with the IEP team. So, at the kind of lowest level of intervention, there's sometimes expert teams where you can bring somebody from the district level or somebody even outside the district to come in and kind of give that extra input to the team about what the child needs. Another option is something that's called a facilitated IEP, which means that there's somebody who's specially trained in kind of resolving disagreements. They may work for the district or work outside the district, but they come in and they try and help facilitate a good discussion with the IEP team to resolve the issue. So it's still an IEP meeting just like you'd usually have, but you just have that extra person there to help you try and resolve that dispute. Another option is what's called a compliance complaint, which we'll discuss more on our next slide. A resolution meeting is something that happens outside of the IEP process, where maybe you're meeting with somebody like the special education director and trying to talk through things more on a one-to-one level outside the IEP to talk through that disagreement and try and reach an agreement with the team. And sometimes at a resolution meeting, the result will be a new IEP that gets confirmed with a new IEP meeting, or it might be an agreement outside of the IEP that provides specific supports to your student. Due process is another option, and mediation as part of that to resolve disputes, and we'll discuss that more a little bit later. And the goal of all of this is trying to resolve differences, remind everybody that we're all trying to work towards the progress of this child. And these are just some different strategies that you can use to resolve those disputes. So many of the different techniques described on this slide, like the facilitated IEP or mediation, fall under what's called alternative dispute resolution. What that means is it's an informal method of settling disagreements that might arise during the IEP process. It uses specific options to promote understanding, open communication, and satisfying solutions to conflict that not just resolve the dispute that's happening, but try and support and strengthen the relationships. And it's designed to meet the interests of the parties so that everybody ends up with something that hopefully meets the needs that they've expressed, rather than having to live with a decision that's made by somebody outside of the process, like a hearing officer or a judge. It's important to know that some H.E.A.R.T staff are certified in ADR, and for the reasons we just discussed, often this can be a great way to try and resolve disputes without having to go through the complaint process. If the ADR process does not work, though, there are some options as far as complaints. One of these is called a compliance complaint, and this is an investigation that's done by the State Department of Education. You can start this process by sending a letter to the State Department that explains in what ways the district is not complying with the law. So as an example, if your child's IEP requires a specific service, but the district isn't providing that, that's an issue of non-compliance with the law. They're not following what the law requires. And so you can initiate a compliance complaint for that type of issue. When you initiate a compliance complaint, the California Department of Education has 60 days to investigate your complaint, determine whether the district followed the law, and if they didn't follow the law, then they need to order them to take specific actions to come back into compliance with the law. So with the compliance complaint, that gets sent to the California Department of Education, and we'll provide you with the address and email address where you can submit those complaints. This process is different than due process. The main way is that compliance complaints are for issues that are more black and white, like the district hasn't met a timeline, the district isn't giving what it agreed to commit to in the IEP. What it's not for is more disputes over what should be in the IEP. So you feel like your child needs more occupational therapy services than the district is providing. That's not generally something that you could bring up in a compliance complaint, but you can bring it up in what's called due process. On the other hand, with the compliance complaint, it's a complaint process, but it is a little bit less adversarial than due process. It's, like I said, it's an investigation. It's not a trial. You're not going in front of a judge, and it does tend to be a much more parent-friendly process than due process is. So there are benefits to this process over due process if the issues fit your specific situation. We're going to talk next about due process, which encompasses alternative dispute resolution, mediation, and then also hearings. Due process is a complaint that you can file when you can't reach an agreement about what should be in your child's IEP. And it can be initiated either by the parent or by the district if there's some type of dispute over what needs to be in the IEP. With due process, you can file complaints over issues going back up to 2 years. It's a little bit longer time period than compliance complaints, which are only up to 1 year. Once the due process request is sent to both the school and the Office of Administrative Hearings, the school has 10 days to respond to what you raised in your complaint. If the school thinks that parts of your complaint aren't valid and that they don't raise issues that are legal violations, they have 15 days to let the judge know that they believe the request is defective. Then after that, the judge would have 5 days to determine if your complaint does meet all of the requirements. With due process, even though it is an administrative court proceeding, a lot of times it doesn't actually reach a trial. Most due process cases, I believe the number is up to 99%, get resolved through what's called mediation or a resolution session, these alternative dispute resolution type strategies, as opposed to actually going to a hearing. And so that requirement to have ADR is actually built into the laws and timelines around due process. So what's required is that within 15 calendar days of receiving the due process request, the school has to set up what's called a dispute resolution session. It's sort of like an IEP meeting because you'll be meeting with some of the same people you often do, but this time the focus is on actually resolving the issues you raised in your due process complaint. If you reach a resolution in that session, the school then has 30 calendar days to implement the changes that you agreed to. But if the resolution session is not successful, then the pre-hearing conference and the hearing will be held after that. You can also, as part of the process, request what's called a mediation, which is another form of dispute resolution. In that situation, rather than just meeting with the district independently to try and work towards a solution, there's a mediator there who's a neutral third party from the Office of Administrative Hearings who's there to help you and the district reach an agreement with each other. And that can be a really powerful tool to try and reach an agreement that is satisfactory for all sides rather than going to trial, where you have the challenge of proving up your case and proving up the solutions that you're trying to request. If you do end up going to hearing on your due process request, then after the hearing is over and everybody's put on their witnesses, put forward their evidence, the hearing officer has 15 calendar days to issue a written decision as to whether the law was broken and if it was, what the district needs to provide to the child. So just a refresher from our last session, there are many local resources available to you, and we have some slides here that list out what those resources are. So remember, some of these local resources are H.E.A.R.T.S Connection, the Kern Regional Center, California Children's Services, the Kern County Office of Education, Kern High School District SELPA, and some of our local school districts. There's many of them, but just a few here are Bakersfield City School District, Panama Buena Vista, and Sierra Sands. So again, we want to leave you with a quote to try and continue to give you some encouragement throughout this process of advocating for your child. Keep in mind that as parents of children with disabilities, we don't have the power to make life fair, but we do have the power to make life joyful. And we know that family and support from family is a huge, powerful difference maker in children's lives. We've reached the end of training 2. We're sure that you may have extra questions that may not have been addressed here. If you do, feel free to go to the link below and add in your questions, and H.E.A.R.T staff will respond to you with answers. There's also going to be a frequently asked questions sheet that's posted up on the webpage. Thank you all.